Hi everybody and welcome to this episode of SEN Talks. I'm here with Adam. Hi Adam.
Hi everyone, nice to see you again.
Now, we have been delivering talks to schools, parents, charities up and down the country since the white paper came out. And we wanted to record a podcast for you guys to explain exactly what those changes or those proposed changes look like. So that's what we're here to do today. So we've got some notes as well so that we can set it out really clearly for you guys and you know exactly what it is that's potentially coming up. Now, the first thing to note is that the proposed changes are exactly that. They are proposed. It's a white paper, which means that there's still some consultations to go through and the House of Lords have to get their hands on it. And there is a challenge on it as well, isn't there, Adam, at the moment?
Yeah, I can't remember where we've got to with the challenge, but I know that the government have responded. I think there was a potential judicial review over the legality of the consultation itself. I think at the moment there has been a response from the government and the firm who are doing the potential judicial review are looking at legal challenges and whether they can at this stage take the matter forward or have to wait for, I suppose, the draft actual legislation. So to give you a kind of, I suppose, highlight of that, essentially the government has said that it really wants to hear from parents about the white paper and their views on it. But there are key elements of the white paper where there isn't the opportunity to actually give your views. The main ones being the reduction in parental rights to the SEN Tribunal and the powers of the SEN Tribunal. And what is described, I think, by the SEN jungle as the Trojan horse, which is actually, although we have an EHC plan agreed in law, it's going to be a very different document, and there's no ability of parents to actually comment on that side of things as well.
It's a consultation element, isn't it, that parents haven't really had the opportunity to respond to these proposed changes properly.
Yeah, I mean, some highlights from me. There are some positives with the white paper, which we'll go through, but there's a lot, I think, there which is concerning and I think actually very worrying. But I think we need to give the context to people who don't understand how we got to a white paper, what the white paper is, etc.
Yeah. So that's like the vision and the motivation behind the changes of law, because obviously to our parents, we're thinking, why is the law changing? Because the law in and of itself, or in my opinion, I imagine your opinion as well, is fine as it is. It's the implementation of that and the access to justice in terms of the time that it's taking and the young people accessing that help that's the issue. So what do you think is the motivation and the vision behind these changes?
I mean, I think if we went back to when the Labour government came into power just before and we looked at their manifesto at the time, the manifesto was very limited in terms of what Labour were going to do with SEN reforms. In fact, really all it said was we want to make mainstreams more inclusive.
Yep.
There was no kind of fundamental change in legal rights or restriction of tribunal power. And I think the argument from many parents with children with SEN is if they knew that these the white paper which discusses these changes in rights, if they knew about that, they probably wouldn't have voted for the Labour government in the first place. So there's a real issue there in terms of how clear the Labour government were about the reforms that they were going to bring in.
That manifesto was quite wishy-washy, wasn't it? It was quite broad.
Yeah, I mean, it's cool. I think it's been described by many kind of commentators as a kind of Ming vase, which is a very safe manifesto which doesn't really tell anyone what the government wants to do. I think the context of that, which was
very fragile.
Yeah, and I think in the last bits of the Conservative government at that stage, I think the feeling in the country at the stage, which has been kind of borne through with the change in government, was people were fed up with the government at the time. And I think maybe the spin doctors in the background were very much like, if you just keep an even keel here and don't upset too many people, you'll probably be looking at getting into power. Yeah. So I think the shadow government at the time did not want to do anything which would majorly upset people. And I think with SEN reform, I've read Keir Starmer saying the thing which comes up over and over again in his government at the moment is EHC plans and the difficulty parents are having.
Yeah.
So it's clearly something that the shadow government at the time would have been aware of when it was coming into power, was a big issue. And there are some kind of fundamental question marks about, whether this was always the intention to bring in these kind of SEN reforms when they were not in power, or if it's something which has been formed during this time. And I think if we went back and looked at the kind of the history of leading up to the white paper, that's interesting itself. So throughout 2025, there was a lot of, I think it's called kite flying, which is where maybe those in government have been putting ideas of change into the press and seeing really what the responses to that are. I mean, it could be other sources are providing those potential leaked changes that were coming through in the press, or it could be central government.
We saw it, didn't we? It's almost like testing the waters. So for context to those listening, we speak to parents all the time. We have potential new client inquiries. We speak to teachers. We're constantly in this world. And every time something would come up in the press, you and I would get phone calls from contacts or parents or clients saying, oh my God, this has come out in the press. Do you think it's going to happen? Obviously, we don't know the answer because we're not in government, but it did cause a lot of worry. It did cause a lot of angst amongst the SEN community. But I think you're right. I think it was testing the waters to see what the public reaction was going to be to changes. But I don't think it made any difference, to be completely honest with you, because, the changes...
I mean, well, it depends on how draconian you think those changes...
Yeah, we didn't see the first draft, did we?
Yeah, so, if we went back and looked at 2025, I think the kind of first stage that I became aware of potential changes was about February 2025. Where there was discussion about effectively removing the EHC plan system entirely and replacing it with something new. Then later in that year, there was discussion about them basically making judges in the SEN tribunal redundant or giving them notice of that.
Yeah, getting rid of the tribunal.
And getting rid of the tribunal. So you have to kind of question whose benefit, I suppose, that kind of kite flying would be. But, I think when you're dealing with parents of SEN who are already kind of very anxious and dealing with a lot, it's actually, I think, caused a lot of upset and unnecessarily so. And I think the problem throughout 2025 is the Minister for Education basically wouldn't commit to anything, wouldn't kind of outline any position. The most you could get is there will be some protection for rights for kids with SEN, but not really outlining what that is.
Yeah. The thing that the headline that would always come with those press conferences from my memory was, we're not getting rid of EHCPs. We're not getting rid of EHCPs. And as we're going to discover in a minute, the term EHCP is still there.
Well, I feel like there was a lot actually of not even confirming or denying that they were going to remove EHC plans. The only thing they would say is that there would be some sort of protection or rights, but no kind of clear guidance in 2025 for what that was going to be. And I think that led to obviously a lot of upset and concerns from parents and kind of lead charities. I think it led to Save Our Children's Rights effectively being formed as a kind of action group.
Guys went for a protest. I know many of our listeners did as well.
Yeah, so I mean, that was in autumn 2025, which was after so many leaks had been brought out about changes. There was suggestion that the white paper at the time was going to be produced, I think, in about May 2025. Then it got delayed. I mean, that was at the time where the government effectively was defeated by its own backbenchers on disability living allowance and PIP changes and reforms that they wanted to make. So it might have been delayed as a consequence of that. And then I think they left it the whole summer with parents worried about, effectively their children being taken out of the schools that they were in, if they're in special schools, or their support being reduced. That led to a protest outside Parliament in the autumn, something that myself and my wife Scarlett attended and was really well organised by Save the Children's Rights and also by charities like IPSI and SOS SEN, and also a lot of, I suppose, parents who are on Instagram who are kind of raising those kind of SEN parent rights and their children's rights.
Yeah.
So it was really well attended, and the government, which was going to at that time bring out the white paper, decided that it wasn't going to, and it was going to consult parents about effectively what they thought the changes should be. Now, both me and Scarlett tried to get onto some of those discussions, but the tickets for it were always basically unavailable.
I don't know anyone who's been.
Yeah,
I actually don't.
So it's I suppose if you're looking for a pool of parents to discuss, I don't know how many parents actually got the opportunity. And I suppose the question is how much it actually has affected what the government have done anyway. I mean, it's often very easy to say we're listening, but just basically giving lip service to that rather than actually properly listening.
No, I get that completely. And we're just gonna go on to talk about the process now, but I do feel like there's a massive marketing campaign behind this, because I follow the DFE on Instagram, and Bridget Phillipson is on it with making all these reels. Like, you can tell that she's uncomfortable doing it, but it's almost like propaganda. So she'll pick up a phone. There's one where she picks up a phone and she says, "Are we listening to you?" "Yes, we are." And then she looks at a phone and she'll read something and then she'll say something. And then that's like, "Oh, we're listening to you," because I've got a phone in my hand and I'm looking at a comment. And it's like, but then when you go into the comments from actual SEN parents on that post, you feel like, I'm not sure you are listening.
Well, it's that again is interesting in the context to all of this, because there has actually been a lot of criticism about Bridget Phillipson and how much the government is actually listening. And if you look, as you say, at the comments on Facebook and Instagram, where there have been kind of these discussion points, overwhelmingly parents have basically said we don't agree with the changes where you'll be reducing what is in an EHC plan, what it is. We don't agree with the kind of approach which is being taken. There has been, and I don't think they are substantiated, reports of people being blocked for commenting, and also certain comments maybe disappearing. The marketing campaign, I don't know, was it like something like 70 million for the campaign for this legislation?
I wouldn't be surprised. There's so much, like, I almost feel like it's a bit like propaganda, to be honest with you. I don't know if that's appropriate to say, but
if you have to spend that amount of money to convince people that the changes you're bringing in are positive, it kind of gives you some red flags there, I think.
Yeah, I agree.
But I think there has been a lot of kind of trying to introduce this kind of change and basically make it very positive. And I think the biggest kind of concern for many of the charities involved with it, who have responded to the white paper, obviously the lawyers who are here to kind of protect the individual rights of those with disabilities, have real concern about the restriction of rights. And I think the majority of parents that I can see are commenting very concerned about all the changes.
Yeah.
So I think when we've had such a build up to this thing, I think it was a bit of a relief when they didn't bring in the white paper in October time, because it felt like the government were doing what they're saying, which was listening to the protests and concerns. And it should be said in the context of this that the government was suggesting changes to bring in the white paper before it even allowed its SEN review, which is an internal review of the whole system from completing that review.
Yep.
I think that came out in the end early autumn as well.
Yep.
And at that stage, it thought, well, maybe it's not a good idea to introduce a white paper and preempt before you've actually received the SEN review itself.
Yeah, there was like a scurry, wasn't there? It feels like around that time. And I feel like, I mean, I'm not into politics in that way. I couldn't possibly comment, but it does feel like a bit of a scurry. at the moment as well, because obviously next year I think everybody's going to start campaigning for the general election, aren't they? So I think for this year, I think it feels like a scurry, and we're already we're in March now as we're recording this.
I feel that it's not so much a scurry. I think they've had a kind of plan about what they wanted to do. And if you go back and look at the chronology of things, a lot of the suggested changes that they wish to make are introduced into the white paper. Even though there has been such concern by parents, the question is whether there is true listening happening.
Yeah. I feel it's a scurry to get it through now.
So I think that in the context of all of these changes, there's a couple of things which have come through which I find quite concerning. So the first one is one of the things that the government keeps on saying is basically with the EHC plan, there's too many children in special schools and we are not seeing these students attaining at good levels.
Yeah.
And for anyone who kind of understands this area, attainment levels for students with SEN are going to be very different, particularly in special schools.
Naturally.
There's a lot of discussion from the Department of Education over things like students not in special schools not achieving high levels at GCSEs. Well, there's lots of students in special schools who simply won't be able to take GCSEs because of their needs.
Yeah.
But also there's a recognition that students with special educational needs may take longer to do those qualifications and get there anyway. And some of the time it's not appropriate to do traditional GCSEs as a consequence. So I feel like there hasn't been much of a pushback on spokesmen for the government on those points.
Yeah.
Whenever I've seen that mentioned, it's kind of just accepted. But it's obvious, isn't it? Like if you have students in special schools and you have we're talking about multiple different types of needs, multiple different types of cognitive profiles. So sitting there saying in a sweeping statement, we don't believe that students in special schools are achieving at GCSE level actually is a bit silly because, your cohort and demographic is going to be very different.
Yeah. I don't think the education or the schools minister's been grilled enough about it. And I think, if anything, the schools minister, I've forgotten her name, but the schools minister is far more charismatic, in my opinion, than the education minister. And she's kind of able to put forward a better argument. But I think neither of them have been grilled on it enough.
It's always a bit wishy-washy.
Yeah.
And it's never pushed enough about kind of some of the statements have been said. The other one is there are too many students within special schools and the bad guys, which are private equity firms, which I feel have been used as an umbrella for any independent special school. So before we talk about the kind of SEN reforms, let's put that into context, which is I think the SEN review found that students who end up at special school have effectively had 2 school breakdowns prior to ending up at a special school. In most of the situations where students end up at a special school, it's because it's the right setting to meet the individual needs of that child.
Yeah.
Most of the time, that has been a ruling by a SEN tribunal or in the end an acknowledgement by the local authority, which has led to them naming a specialist school environment. The students within those settings often need to be within small classes because of their needs. They often need a higher level of specialist teaching and therapy. The attack, I suppose, on special schools, particularly the independent ones, was I find interesting because most independent special schools are actually charities or not-for-profit companies. There is only a small amount of them which would be considered to be private equity firms.
Mm-hmm.
The reason why a lot of them remain as, I suppose, charities and independent is because they will have a better control over the students that they are taking to those schools.
Yeah, their provision won't be watered down.
Exactly. And, if your cohort of students that you think your school is designed for is dyslexic students, then you want to make sure that the admissions process that you're taking on students with that kind of profile who are, I suppose, functioning at a similar level. So when you are teaching those students, you're teaching everyone at the same level. Same goes for a kind of a more ASD specialist environment or a setting for kind of severe and complex needs. A lot of these settings, the reason why they're independent is so they have much more control over cohorts coming in, control over the staffing, and the way that they do their model of therapy. A lot of time within local authorities, the special schools that you have are often more, this is a very sweeping statement because it's more nuanced than this, but the special schools can be often much more kind of generic in profile. And even if the school says, well, this student doesn't fit with my cohort of students I'm taking on, the authority can still place the student there.
Due to lack of spaces, due to funding, etc. And you do find that provision is watered down. So, for example, the provision that I know from my experience working at a local authority, we had a special school, a maintained special school, and the type of student that they were looking to introduce and place there were both children who had severe and profound needs and children who had a diagnosis of ASD, were highly anxious but had a high cognitive ability. And those two profile of student, it's unlikely that those two profile of student can be educated in one class because their needs are so opposite.
Yeah.
And that's the type of thing that we're talking about, isn't it? And that's why all of the schools tend to retain their independent status so they can take control over that.
Yeah, no, it's really important because especially with a lot of the students having been within a mainstream environment where the mainstream teaching isn't set to their needs, it's usually the first time where they've got direct teaching approaches and therapy to address those needs. And, as we said, it's usually their third placement before they're there. So I think that kind of messaging is obviously incorrect, but also it's kind of concerning because I think the impression it gives is pushy parents trying to get their children into independent schools. And I think in the eyes of the general public who may not know this area very well, it will be kind of bowler hats and stripy blazers and that kind of impression of an independent school. But actually the independent special schools, most of them are purely focused on delivering provision. Most of the students are also, because of their sensory needs, the uniforms that they have are designed to be comfortable. So they're usually in tracksuits, etc.
Yeah.
But I think that kind of stuff is dangerous, and it's, I think, reframing potentially who the bad guys are in this situation. And when we look at private equity, admittedly, there is an issue with private equity within the SEN world, I suppose, in the sense that there has been, and this isn't for all private equity because there are some very good schools run by private equity firms, there is a small, tiny fraction of those schools where the funding of those schools is significantly higher than other areas. And obviously there's a lot more scrutiny about why that is the case. We can't judge why a school would be charging out a certain rate. That's kind of outside of our area to discuss, but it's a small amount of schools. I'd say probably of schools which are owned by private equity, it's probably like 0.1%. But I feel like at the moment it's being used as an example for everyone.
If that was the issue, then that could have been addressed in a different way, right? Why go after the children, young people,
well, also,
and their rights?
The reason why I think private equity in that situation, I suppose, have stepped in and built special schools and invested in that way is there was a demand, and
exactly
there was a complete deficit in terms of special schools being built by local authorities.
Exactly. Adam, how many cases do you and I have where we simply don't have a school for our child or young person to go to? I've got at least 7 where there's no school on. We can't find, we simply can't, neither us nor the local authority, working together in tandem, can find a school that's suitable and has a place for that child or young person.
Yeah, and I think the other thing as well is when you look at kind of schools, special schools, both state special schools and independent settings, the cost of them has increased significantly, I'd say, over the last 10 years. There is a shortage of therapists to hire. There's a shortage of specialist teachers to hire. There's a shortage of specialist care staff.
Yeah.
So the costs have gone up in both environments. Special schools themselves used to be much cheaper in terms of a cost to a local authority to sit a student there. These days, in a lot of the cases we're involved with, once you actually forensically look at the costs, that it's usually on par with the other school that parents might be seeking.
Yeah.
So I think there's a danger there as well. I I think the other kind of boogeyman, and we'll talk about it in a minute, is apparently us SEN lawyers. So, I mean, that one's a surprising one. So recently, after issuing the SEN white paper, I think everyone took a breath to actually read it. At about a week after it was produced, people started to comment back about the concerns about the paper. And I think Bridget Phillipson said she was a little disappointed with SEN lawyers and their challenge to the white paper. And I think suggested that we have a vested interest in the system remaining as it is.
Yeah.
Which I find infuriating and upsetting, I suppose, personally. I mean,
you're a parent of children with SEN and an SEN lawyer as well, so you can kind of feel it from both perspectives, can't you?
There's a lot, there are a lot of, I suppose, SEN lawyers, and I would call myself an education lawyer because I'm not just doing SEN work.
Yeah, of course.
And I would also say when we say SEN lawyer, I actually see myself as a disability rights lawyer, if we're going to be clear about it.
Disability claims as well, yeah.
Exactly. And
admissions, exclusions, we do everything that touches education.
So a lot of the lawyers who practice in this area, a lot of them have disabilities themselves, or they have children who have disabilities and SEN. So I suppose it's not often a route which people in law school say, I want to be a SEN lawyer. Yeah. It's something that, because of their own journey, they end up practicing in. I think there's only few lawyers out there, including me, who always wanted to act in this area. And that's really because of my experience of being within a mainstream school, it not working, kind of unable to access that environment and ending up in a special school myself. Yeah. And feeling as an adult very grateful that I had the support out there to go to a specialist school, develop my skills, which have allowed me to kind of build the skills that I needed as an adult to hold down employment. And this is the whole point of this system, or should be. So the attack on SEN lawyers, I think the context of this is, if you're going to attack SEN lawyers for protecting the rights of very vulnerable people with disabilities, you might want to consider whether that's the right thing to do. We're there as a kind of safeguard and a bastion for those people to protect them and to ensure that they get the right type of support. Yeah. And if you're going to make that kind of attack, maybe you should talk to your boss, which is obviously Keir Starmer, who last time I remember was a very famous human rights lawyer.
Yeah, he is.
Before he became a politician. And
yeah, we all learned about him in law school, didn't we? We all knew who Keir Starmer was before he went to politics.
Yeah, and I suspect if you looked at Keir Starmer's history of cases, there would be cases against the police, the cases against the Ministry of Justice, I suppose, and there'd be cases against the Ministry of Defence as well. Yeah. So, you know, if you're going to make those kind of statements, I think you have to be a bit careful to make those kind of comments.
The president of the Law Society isn't very happy with that statement either, is he? Because he was asked to comment on it in the Law Gazette, and he wasn't very happy with that attack.
Well, lawyers are...
Felt very validating to feel the president of the Law Society sticking up for
Absolutely.
us.
And I mean, the comments are completely right, which is, you know, lawyers in this area, we're all regulated, and we have a duty to do the best by our clients as soon as practically possible. Yeah. And, you know, there are some question marks, I suppose, about other areas of this area which are unregulated in terms of representation for parents. But we can't really comment on that because that's not in our area of expertise.
No, we ourselves are regulated. And also, I think what, kind of touching on what you said, is in that we are representing the weaker party. Because these cases that we are bringing in the SEN Tribunal are against a local authority, a large government organisation, a large body. And often a lot of our parents come to us and they say, well, the local authority said this, so there's nothing I can do. The local authority said that, so there's nothing I can do. I've got all of these expert reports and the local authority said that they're useless, even though I had to have waited 2 years for an NHS diagnosis. I've got my diagnosis myself, but I can't use them. And they understandably trust what the local authority is saying, right? But when they come to us and we say that's not quite true, and they can take your diagnosis into consideration, they can use all of these reports, and just because they don't have an educational psychologist to see you doesn't mean they can breach their statutory deadline for an assessment, for example. Parents are dumbfounded because they are the weaker party. And if we weren't saying that to these parents, how would they know? How would they know? So I don't understand how we're exploiting the system.
We are a kind of key bastion to ensure that parents and their children's rights are protected.
Exactly.
And the statistics show that. We know that the SEN Tribunal, the figures from the SEN Tribunal in favour of appellants, so that's parents bringing those kind of cases, is, I think, over 95%.
That's very high.
So what that tells you is that local authority decision-making is very poor, and they are overturned significantly at tribunal. And, it's not the independent special schools, it's not special schools as a whole which are the problem, it's not SEN lawyers. You might have a problem in terms of how your local government, I suppose, are considering these cases, and I suppose whether they should be defending them in the way that they are. We've talked about this before, where there has been, I think, a change in habit in the last, 5 or 6 years, where not all local authorities, so I don't want to brush all local authorities with the same brush, because we have very good relationships with some and we can have a good conversation and usually resolve things. But you do feel with some of them that there is a kind of insurance company stance in it, which is deny everything for as long as possible, delay it as, an outcome as long as possible, and by doing that you hope that the person will go away. So they'll remove their appeal, or they will accept something which isn't right for their particular child's needs. So when you're talking about vested interest in children with SEN, ensuring that they have good outcomes, we play a key role in it. And as we're going to talk about when we look at the white paper, if anything, I feel like the system, I don't think this is the intention of the government, but I think it's going to end up being this, is going to cause a situation which is more adversarial and a less kind of working together kind of approach, which I think is the government's aim with all of this.
I wish I could go into the walls of Westminster, but unfortunately I can't. So if we go through what the changes look like. So for those of you listening, there is a 4-tier of support that's being suggested. The first is a universal offer, and that is going to be for all children. This is what's going to be delivered in schools. The second is targeted support. What this looks like is small group, classroom-based intervention for commonly occurring needs. We don't know what that means, commonly occurring needs. I don't know understanding what that means. But those level of children will have a individual support plan. It will be digital. Thereafter, there's targeted support, and that's for children needing access to expert support. There'll be experts at hand to deliver this support. Don't know what that means. There'll be embedded experts. Again, don't really know what that means. Inclusion bases and short-term specialist placements to stabilise need. Those children will get an individual support plan, which won't just be digital. And then there's specialist support, and that's been reserved for the most complex needs, hasn't it? Requiring a provision beyond mainstream capability and support set out in something called support specialist provision packages, education and healthcare plans, and ISPs. So that's where the EHCP comes into it. But the first 3, there's no education and healthcare plan involved in that. So that's the structure.
Yeah, and I think, again, I feel like I'm being very pessimistic, but I'm going to just say what I think.
I think you should.
That's good. So I don't think we should be patting the government on the back for basically doing something which should have happened 20 years ago. The government's idea with the white paper is early intervention, involvement of experts, say, like speech and language and educational psychologists early in the system. And then for those who are identified with needs, a tier system. What do I think about that? Well, actually, if we went back to 2002, before EHC plans came in and we were under the stapling system and went back to the SEN Code of Practice, so that would be under, I think, New Labour at the time.
Yeah.
That was a very similar model. So we called it School Action and School Action Plus. And the context of all of this is it makes pragmatic sense to have a system like this. So at the moment, when the coalition government brought in the Children and Families Act, at the time there was a lot of discussion about giving schools the individual choice to do things how they want. And nice in theory, but in practice has been a bit of a disaster, because it means that every school in the country has a different way of measuring SEN, has a different way of increasing support, and has a different understanding of when they should have an EHC plan in place.
Yeah, solidifying the postcode lottery, isn't it, really?
Yeah, I think so. Although I always find that term postcode lottery a bit mystifying. Is that the word?
Mystifying, yeah.
Yes, that's the one. Because I don't actually see that in the same way as I think it is being pushed out in the press. So let's talk about that. So the reason why that system hasn't worked very well is because you can't really see what a national standard would be across each school. Same goes for how they understand attainment levels. So up until 2014, how you measured attainment, you had basically a national curriculum where you had levels where you can measure if someone's making progress and where they should be in each year group. And again, that has changed where the government at the time thought it would be a brilliant idea to allow every school to have their own way of measuring attainment. And understandably, that's been a bit of a disaster. So what an impact that's had is there's been inconsistencies across the country in terms of how they deliver provision, inconsistencies about how they measure progress, which I always have felt, and we've sort of spoken about on the podcast before, has led to a situation where students who are not identified as having SEN or may not be getting the support quick enough that they need, which has led to a massive deficit in their learning, which in the end has led to EHC plans. So I think that's what the government is thinking with the tier system is it's thinking if we introduce this early on, there's lots of students who may not need that EHC plan in the future. And for those students who have them, there are some who have EHC plans, and the intention seems to be that they would come off their EHC plan and be at the highest tier without an EHC plan.
Well, it's only the most complex of specialist support that are even going to get the EHC plan. So the ISPs are for the targeted and targeted plus.
Yeah.
And that's all. It's reviewed annually. It's all at school stage.
Yeah.
It's all kind of in-house, if you like. So it's almost like ordinarily available resources, but in Bridget Phillipson's mind, she's going to be funding these schools, giving them more money to put into place this provision. But I mean, what does the most complex need look like?
I mean,
does it look like a child with cerebral palsy? Or does it look like a child with ASD who can't leave the house? Or does it look like a dyslexic child who's got anxiety?
So there's been a lot of inconsistency between the Bridget Phillipson, her Children and Families Minister, and also what the Department of Education have come out with about what we consider the most complex needs being and what that specialist provisional support would look like. I think if we went back to those tiered systems, I think the problem with that, and I think the SEND jungle described it as like a version of the Hunger Games, is you're always going to have students who basically need support quicker than that. And if you're having to go through a tiered system to get there, it means that you can have a situation where the deficit in learning increases over time because you've got to wait to go through those systems before you get to the highest system and then you go onto an EHC plan.
Yeah.
At the moment, our system recognises that there are going to be students out there who, might be of average ability, might be doing well academically, but then have real deficits with social emotional needs and with their speech and language and their physical and sensory. So the problem with that tiered system is it's basically saying, this is what we standardly provide. You're going to have to, the worry is it's like you're going to have to run this gauntlet before you actually get the provision you want, which is not very different from how it is now.
No, it feels very local authority coded, doesn't it? When they say, well, no, we've got to try this next, and then we've got to try this next. And if it's almost like you have to fail at every stage and it has to be not enough and you have to have tried it before you go up to whatever the level it is that you need. So it's like, why do I have to go through all those failures? And like you was explaining, like with the independent special schools, usually their third placement, when we usually have evidence and parental evidence as well, not just evidence from other experts, independent experts, but evidence from the parents to say that we know, based on the fact that we know our child, based on the fact that they've been at this school and it's not working, that a resource unit is not going to help them and they need a specialist placement, for example. But with this system, it almost feels like they must go through all of that and fail at every stage, which only causes more damage.
It does. I mean, I think I think it's a bright idea in the first place, which is you identify really early on, even when babies are basically newborns, that there might be students who have disabilities and SEN at that stage, and you put in the provision quick enough.
Happening anyway.
Exactly. So I really don't feel like patting the government on the back for something that should be happening already.
Yeah.
And I think there's other things which are really positive, which is better training for all teachers about how you identify need and address it within the classroom, which hopefully will mean that students who are, as I think Bridget Phillipson thinks all students are, although I disagree with this, are mainstream, can have their needs identified and differentiation in the classroom, which is wonderful in theory. But when you've got 30 students in the classroom, I don't know how realistic that is. But I think training all teachers on how to identify and how to differentiate their learning opportunities for students with SEN is a good idea. So I think that's good, but I also think it's an obvious idea. And we've spoken about this going back to when the last government were in power about that as something that they should be doing.
Yeah, when we had a green paper. We were talking about it back then. But it feels like, I know there's been lots of, we're going to talk about the specialist provision packages in a minute, but I think there's been a bit in the papers about this system being based on like a Scandinavian system, maybe in Denmark somewhere, where it does work quite well. But I think what they're not being challenged on is, yes, but in those countries they're very affluent and there's 20 children in the classroom. They start school far later. Children start school far later because they're able to develop in play, etc. That's just the way that they do it. They're more mature when they start school, for example. They've got a lot more resources available to them. So we're a very crowded country here in terms of schools. There's not enough schools. There's no school places even for neurotypical children. And I think like the two don't marry up.
Yeah, I mean, look, I think with my own, so using one of my sons as an example here, when we started the application process for his EHC plan, the school at the stage said, usually at this stage, our local authority would say you need to do 3 cycles of provision on the equivalent of, I suppose, your tier 2 level before we were considered doing a needs assessment.
In this, it would be targeted support, wouldn't it be on this standard?
Exactly. And they said, there would be no point in us making that application on your behalf because it would be rejected. So naturally, I did it myself and pointed out that all children develop at different stages. Yeah. And with my younger son, because of the complexity of his needs, and at that time he was supposed to be in full-time nursery and couldn't cope with more than 2 hours, the idea was that having to wait, 3 cycles of provision was simply delaying putting the provision he required in place quicker. And the school at the time often said to us, we'd love to have a sensory room within the school, but we don't have the resources for that. So I suppose that's an element of the change that the government has also suggested, which is they're looking at having SEN hubs in every school.
They have said that.
They're focusing on secondary at the moment, and then they will aim to do it, I think, with primary at the moment. So what that SEN hub looks like and how we're going to ensure it's not the broom cupboard at the end of the school is going to be interesting. Most schools would have a room where the SENCO will be in and will be delivering provision to students. So I'm not sure about how different that approach is going to be. But I do think maybe having a central area in every school, because it's inconsistent for kids with SEN, would be good. But to be very clear to anyone listening to this and saying, is that the same as a resource provision? That resource provisions are what we call kind of, things like autism resource provisions within mainstream schools, for instance, will be separate from that. So every school will have a SEN hub. It will be...
Yeah, so they're called, I just wanted to get the proper name for them. So the first will be support basis, and that's what we're talking about. That's what you're referring to, a SEN hub. And then there'll be specialist bases, and they are the equivalent of an alternative resource provision now. So every school will have a support base according to these new changes, but some will have specialist bases, which will be commissioned and funded by the local authority to deliver that specialist support. And there's something like 3.7 billion that they're going to put into place between now and 2030 in order to put that into place. But what they're saying is the expectation is that every secondary school, like you said, will have an inclusion base. And I think inclusion base and specialist base have been used interchangeably with the equivalent number of places in local primary schools. So they're thinking about secondary schools first, which is an odd way to think about it, right? Because we all know that early intervention is key with neurodiverse children.
Maybe it's just practically that there's usually secondary schools are bigger, so they might be easier to develop that hub, whereas a lot of primary schools, generally, there isn't much space in them.
Yeah.
I think, when we talk about the tiered provision system and stuff, we should say that the idea from the government is schools will have an educational psychologist and speech and language therapist going in regularly into those settings. And basically, it seems like they are not delivering towards the students, but almost upskilling staff and continuing to provide provisions to staff about how to use best approaches. I don't think that's very different from a lot of the provision out there at the moment. Outside of EHC plans, most schools have, those types of professionals going in. I think maybe standardizing your expectation, I think that's a good idea.
Yeah.
The suggestion that it might not be direct work with the students, I think, is quite frustrating, because sometimes I think you need to work with those students in order to understand their profile, and that can take some time of individual work. The other thing which has been raised by a number of charities in this area is the reality of actually recruiting all these additional educational psychologists and speech and language therapists that they're talking about.
Do they exist? Tell me where they are.
Yeah, and we've spoken about often a lot of talk about speech and language therapists and educational psychologists, less in the white paper about occupational therapists.
Yeah, sorry guys.
I mean, they are in there, but they're not mentioned as much.
No.
And I really question that, because obviously occupational therapists play a key role, but they're often the ones who would sit there and say, well, because this student's sensory needs are significant, they need a smaller environment. So question mark over why they may not be mentioned as much.
That is very cynical.
It is very cynical.
But you have a point, because that's a lot of the time that is what is relied upon for the small environment alongside the educational psychologist, but it's usually acoustics, noise, visual aids, just the space in the room. So I agree.
We should say before we go on to the next stage, because I think maybe some parents will be sitting here very anxious about this. The idea with students who have EHC plans at the moment is that they will look at changing those at phase transfers. Obviously, the law hasn't changed yet, and the law is probably not going to change until about September 2029, I think.
Yeah.
But for those who have EHC plans, the government has said that they are not looking to move students and look at putting them on a different package of support until...
Not yet. It will be phase transfer, wouldn't it? So for anyone who has a plan, that would be from primary to secondary. It will be post 16. It will be post 19.
Yeah,
we're a bit early for anybody to be from nursery to primary at the moment, unless you get in
the government has said that those
next couple of years.
Yeah, those who are in year 2-ish will be different. They'll be moved on to or put onto the new system earlier than that. So I think that's important to put in context, because I think a lot of parents will be very anxious. First of all, the law hasn't changed, and things change a lot from the white paper to legislation usually.
Yeah.
But the other thing is I feel like when the government said that, it was to maybe reduce anxiety, but also for maybe people to think, oh, this is okay, without realising all of the potential pitfalls that we're going to discuss in a minute.
So moving on to the specialist provision packages. So these are, the best way I can describe them to our listeners is they are kind of bundles of funding that can be allocated to the education and healthcare plan. So the local authority, the government are going to work with an independent national expert panel. We don't know what that looks like, in order to put these packages together. But for an example, there are packages based around heavily adapted curriculums. So, for example, significant executive function, profound multiple learning needs. There are, and complex executive function and communication. So those are all like bundles of funding within that specialist provision package. And then there's packages based on adapted delivery of the curriculum, including providing a different environment, So that's based on the bundles are externalizing behaviour and internalizing behaviour. So anxiety, SEMH, that's the kind of things that we're talking about there. And then packages based around provision needed to enable access to the curriculum. So sensory impairment and physical disability. So we imagine, and obviously all of this, for those of you who are listening, are our musings, if you like, because we don't actually know. So a lot of it's guesswork. So we imagine what that's going to look like is when you have an education and healthcare plan for those who are considered in need of one, the most complex in our societies, as the government have put it. They will have these bundles of packages kind of cherry picked according to needs and attached to the education and healthcare plan. But it's the individual support plan that will detail the provision that's going to be put into place. But the education and healthcare plan will include details of these little bundle funding packages. So I think it's been referred to as a Trojan horse before, or maybe shrinkflation, if you like. So the name and the packaging is still the same, but the contents of the educational healthcare plan is significantly different.
Yeah, so I think the first thing to say about it is the current system at the moment is being brought through since basically the 1980s as an individualised system, recognising that students with SEN develop differently from their kind of mainstream peers. And the idea is a recognition that the one glove mainstream education does not fit all. Yeah. With the EHC plan, it is basically the first time where provision is fully specified and quantified and delivered to address a particular individual child's needs. Now, before this white paper came through, there was a lot of kite waving in the press about basically completely getting rid of the EHC plans. I think the backlash from that in the press and from charities in this area has led to the government basically changing course, but not changing course that much. So why is this a problem? Well, I think the first thing to say is the reason students end up with an education, health and care plan is the packages of provision provided within mainstream schools and locally in the NHS are insufficient in addressing need. So what we do is we look at focusing specifically on the individual child's needs and what that individual requires. And the system, partly through legislation, partly through guidance over the last 40 years, has become quite it is a good system. It is already very sophisticated, and it's one that delivers for those who have EHC plans. No parent I have spoken to or have seen commenting on what the Ministry of Education has been doing, or even when the SEN review has sat there and said, do you know what's a brilliant idea? Let's change the EHC plan so it's no longer about specific individual needs, but make packages of provision. The reason why that's the case is usually before they have an EHC plan, they've gone through block therapies within the NHS, which is just simply insufficient in addressing needs, or they've had a package of provision within school which can't meet need. Mm-hmm. So we are going back, I think, effectively to the 1980s before the good system that we have was in place. And this is one of the things which drew Bridget Phillipson's frustration, I think, from SEN lawyers. The irony about that situation was most of the criticism had come from lead charities in this area like IPSI, like SOS SEN, through parent groups like Save Our Children's Rights, and also through the Autism Society, all raising the same issues. So these are not SEN lawyers profiteering or anything like this. This is clear charities protecting individual rights, impartial from the government, raising real concern. So I've heard it described in very different ways about what we mean by these SEN packages and why we should be concerned about them. So the SEND jungle, as you say, refers to them as being a Trojan horse. So that means having a gift, and actually it's not a gift, it's quite something sinister. And then I've heard a brilliant, I think it was the head of Save Our Children's Rights, describing it as if you go into an optician's and they put lenses in front of you and you sit there effectively until you can see properly. If you can imagine a situation where you go into the opticians and you're going for the prescription that you know meets your eye needs, and they said, no, we're not doing that anymore. We have standardized lenses that you can use. And then you're given basically a lens which you can sort of see from, but you can't really. But it's a standard lens and that's all you're going to get.
Mm-hmm.
That's the big concern, which is if you have standard packages of provision, then you have a real concern that you're basically going to end up with a situation which has led to this crisis in the first place is lots of students are not going to get the provision they need. So the deficit in their learning becomes bigger.
Yeah, fundamentally, all of our children aren't the same, aren't they? Yeah. How many children have we seen? There's no child that I've ever worked on, their case is the same as another. Yeah.
I mean, the way I was talking to a friend about it the other day was like, it's almost like someone saying, we're going to take away your smartphones. Nobody's going to have smartphones anymore. And everyone says, well, that's outrageous. We all need smartphones. We have our banking apps on there. We have our organisers on there. It's the way we communicate, emails, WhatsApp, etc. And then the government thinks, okay, well, the backlash has been terrible about that. So what we're going to do is we're going to give everyone Nokia 3210s or brick phones.
Yeah.
But we're going to cover up the 3210 and put iPhone on it or smartphone.
We're going to call it a smartphone, yeah.
It's a smartphone. What are you complaining about? Yeah. But obviously, it can't do all the things that are necessary for our day-to-day lives. And I think that's the way I look at this. All good analogies because they're basically saying the same thing, which is our system at the moment recognises that individuals require support in line with their EHC plan. And the individual support is based on that person rather than trying to fit a person around the package support available. We always believe in it being needs-led, not service-led. And I think that's the concerns with what's coming. And I don't think that any parent or charity in the area thinks that this is a good idea. And it is a reduction in parental rights. There's question marks about if you're not getting the right level of support in your SEN plan, your individual specialist provision not outlined in the EHC plan, that the only way you can challenge that is actually to challenge your school that your child is attending about the provision and go through their complaint system, which allegedly is going to have a SEN expert on the complaint system to deal with that. And I suppose if you're not happy with that, it's to go to the Department of Education at that stage.
Yeah.
That was very much the system in the 1980s. And we abandoned that system because those with SEN were not getting the right type of support. So why it's a brilliant idea to go back to that, I don't know. My suspicion is, as a lot of parents were saying, that a lot of this is austerity measures being painted as inclusion. And actually, in a lot of regards, it's actually the opposite. It's being included, but still being excluded isn't the same thing. Yeah. And then I think we're on to the rights to tribunal, right?
Yeah. So with the appeal and the challenges, obviously the first thing that one's mind goes to is the Section 42 duty, because currently, as you know, as our listeners know, under Section 42 of the Children and Families Act 2014, there is an absolute duty to deliver everything in an education and healthcare plan. That's why we need it specified and quantified. And that responsibility lies with the local authority. With these new changes, obviously there's going to be less children with education and healthcare plans. And the local authority will retain overall ownership of the education and healthcare plan, but they will share that Section 42 duty due to the ISPs as well with the school. The government haven't been really clear, and the white paper doesn't set out exactly how that's going to work specifically, or whether the Section 42 in the Children and Families Act is still going to run. I mean, I don't even know if they're going to completely scrap the Children and Families Act 2014. It's not 100% clear. So,
I mean, personally, I think it's just an awful idea for many reasons.
Yeah.
The whole point that, again, if you went to the SEN review kind of report, often parents feel that by the time they got to an EHC plan, it's the first time where their children are getting the provision they need. And because it's specified and quantified, they can ensure that it's actually delivered. So why are you basically putting us in a situation where potentially provision isn't specified and is vague, and you're going to have a SEN plan which the school have outlining what they'll do?
Yeah.
There's loads of problems with that, which is, the natural one being the reason why often people end up with EHC plans is, one, they need them, but they need that specificity and that quantification and provision. If we end up in a situation where things are not specified and quantified in the way they should be, we can end up with students not getting the provision. So sharing that duty with schools in terms of delivery, in reality, the legal duty is on the local authority. Pragmatically, actually, usually it's the schools delivering that. But importantly, when schools are not delivering it, the idea of being able to challenge the local authority to it is really important. Usually when schools are not delivering it, it's not because they don't want to, it's because they don't have the funding to do so. So, challenging the local authority is key in that. Relationships with parents and schools with their kids with SEN is often strained enough. So putting us in a situation where you're putting a parent through an arduous kind of complaints process with the school that you have to go into every day and deal with, to me is not a great idea. It kind of further dilutes the trust that parents have in schools.
Yeah.
It puts parents and schools against each other, and I don't think it's going to lead to less, I suppose, challenges. If anything, I think there's a real risk that there will be a significant increase in disability discrimination claims.
Yeah,
so.
And to explain that, just to our listeners, the view at the moment is that parents can challenge the settings of the school. So it's bringing the challenge and that adversarial nature into the school setting, and it's schools that's going to have to respond to that. So you can challenge the setting and your school if they refuse an ISP, if the content of it is inadequate, if the provision is not being delivered. That's a Section 42 issue, which usually will be a JR. So I query whether you could do a JR next to it. If reviews are not taking place because annual reviews still need to take place, or reasonable adjustments are not being made. So the routes for challenge for that is a school complaint, appeal to the Governor's Board, and I don't know if new appeals internally in schools are going to be created for the ISPs themselves, or if it's just going to be the school complaints procedure. So extra work for schools as well, extra governance that's going to be put into place. You've got the option to judicial review, but that, of course, is a blunt tool. It's very expensive. You've got a litigation risk, and it's unlikely that it's going to be suitable because judicial review is a remedy of last resort. So if you've got another route of challenge, then that's not going to be as useful to you because judicial review looks at the way that a decision was made as opposed to the contents of the decision. And then the other only, as you say, the other only tool and route of challenge is an Equality Act claim. So are we really seeing, and a lot of those will be for reasonable adjustments, right? So if we want, I don't know, something in the ISP, an increased amount of provision, but the school is saying no, or we need a sensory room and the school doesn't have it, that's a reasonable adjustment challenge. So are we moving? And one of the aims, from my understanding of listening to the news and the media, and Bridget Phillips and herself and speaking to various MPs, is that one problem was that the SEND tribunal was overloaded. Local authorities were overloaded at dealing with these appeals. And it was the appeals that was the problem. But with this new shift, are we just moving the legal challenge from the SEND tribunal into the county court? And are they just going to be disability claims now? Obviously, you can do disability claims in the SEND tribunal as well. But have we just shifted it and potential judicial review? Have we just shifted it somewhere different? And they're much more stressful. It's much more adversarial, isn't it? Because a SEND appeal to the SEND tribunal is you're just saying, well, you're just saying, but you're saying, I'm not happy with the contents of the provision that's being given to my child, and I'm not happy with the placement. With a disability discrimination claim, it gets people's backs up more, and it seems more sinister because you're saying, you have discriminated against my child because you haven't done X, Y, Z.
Yeah.
And schools, because you're bringing the challenges against the schools now, right? Obviously, we'll get their back up. We didn't discriminate, as opposed to potentially local authorities conceding or there being able to be an amicable resolution in the SEND tribunal, which you and I know that we resolve a lot of our cases. I'd say probably 80% of our cases we resolve, versus a disability discrimination claim, which is far more adversarial and feels more sinister.
Absolutely. And I think I think the relationship between schools and parents are often fraught anyway, going through this kind of appeal process, etc. And the idea that you're going to make it more adversarial doesn't seem to me to make much sense. And the damage in terms of relationship of bringing complaints against schools, we see it quite a lot. Unless they're handled in a very careful way, lead to a kind of a school putting its walls up and parents feeling very isolated and the relationship getting worse, not better. So I think the idea of sharing this duty is it's a really bad idea. I think moving away from specific provision to packages of provision, again, is a bad idea. We don't even really know what these packages will look like.
They don't either, do they? They're going to work on it till 2028, they said.
I also don't agree with the idea that you need to change the definition of SEN as is being suggested. So the current code of practice is very clear about what special educational needs are and what specialist provision is. It doesn't need to be redefined. If you truly believe in the changes that you want to make to the tiered provision, if you truly believe that's going to make a big change, then there is no reason to change the EHC plan or to change the definition of those who require an EHC plan, because parents won't feel the need to apply for an EHC plan in the first place because all the provision that you're putting into place is working.
Yeah.
So then you have to question why there's a move of that duty, why you're kind of restricting the parents' ability to go to SEN Tribunal. So it's been reported in the press in the last 2 weeks that just before they introduced the SEN white paper, the government made a U-turn. Originally, it was going to remove the right for parents to go to the tribunal and challenge a local authority and refuse to undertake an EHC needs assessment, which is, for me, deeply worrying that they would remove that right in the first place. There are question marks about, if you are going to tribunal with these SEN packages, what you're trying to achieve and how that kind of bores out in reality. So there's a question mark about why you would make it less specific and more vague, other than potentially trying to reduce what parents are able to obtain at tribunal for EHC plans and what their children need. And obviously the last one, which is deeply concerning, is the idea that from now on, if a tribunal has to look at an EHC plan where there's a challenge to placement, the tribunal can rule against the local authority's school and quash that school, but it can't name a placement. So one of the powers of the tribunal since its real birth has been if a local authority tries to name a school which is inappropriate, it can name parental choice if that school is appropriate. And we've seen cases where the tribunal has found local authority school can't meet need, neither can the parents. You're going to have to both go and think about it again.
Yeah, it's got the power at the moment to step into the shoes of the local authority and make that decision. Obviously, it's an inquisitorial panel. It's a specialist panel, and it has the power, the ability and the aptitude to do that. But with the new suggestion, the only jurisdiction that the tribunal will have is, does the child meet the SSP threshold? Has the correct SPP been selected? And should the EHCP continue? So it can find that a school is unsuitable and it can quash that decision. But there's nothing in theory stopping the local authority going and finding basically an equivalent school, not your school of preference, naming it again. You've got to go through the whole process again.
Yeah, it's such a ludicrously stupid
thing to do. It's just such a waste of time.
Yeah, the question there is, why do you want to potentially reduce a parent's ability to challenge a local authority's decision not to undertake an EHC needs assessment? Why do you want to restrict their ability to get specified provision for a child? Why do you want to restrict parents' ability and the tribunal's ability to find an appropriate setting for a student? The answer to that is
money.
And it's not. It's what frustrates me about a lot of the kind of publicity campaign at the moment. There's a lot of kind of what I describe, or my oldest son has described as sad eyes. So this kind of look of, we really care and we really want to make sure that all these kids get the right type of provision. Look over here, don't look over here about what I'm doing over here. Over here, actually I'm reducing all your rights, increasing the threshold for when someone is entitled to the right support, what can be in that provision, and also the naming of a school. And I think the other thing that we see bolstered in all of this is an argument about public funding. And it frustrates me that that kind of campaigning has now been swallowed, which is this idea that it's too expensive. So let's look at that kind of question about the SEN system as it is at the moment being too expensive. The reality is it is a system which has been underfunded
For years.
since austerity in 2010.
Yep.
And it's an area which, although funding has gone up, real term funding has actually gone down because of things like inflation. It's an issue about recruitment of the right type of support within schools. There has been a systematic failure across the country at having a key strategy for developing and building the right kind of SEN provisions, both within mainstream and in special schools. So the crisis caused at the moment isn't a crisis caused by parents with pushy elbows trying to get through the system. It's been created because the provision just doesn't match the need, and the resource there doesn't address the problem.
There's also environmental factors. Like, I think we kind of forget about the impact that COVID had on a massive cohort of children and a massive generation in terms of their development, in terms of their expectations of school. It changed everybody's lives, and you know, it affected these children and young people, and a lot of them need more provision.
So you have that kind of thing of whether we're at a peak of a wave of situation caused by that, and whether actually, as things calm down in the future with COVID being past, hopefully, never again, I've kind of blocked out most of that from my memory. Yep. I think most people have. That wave of need as a consequence may actually reduce in the future because students are in school, etc. I feel like the other thing, which is it's never spoken about by any minister, and actually is never really mentioned much in the press either, is with the statementing system. So that's what was in place before the Children and Families Act. The statement for most students went to 16. If you went on to college at 16, you had a different thing, which was not legally enforceable. It was like a SEN plan, actually very similar to what they're suggesting here. Yeah. And always there was a lot of problems with that because basically students in sixth form colleges very rarely got the support they needed. So that's why
There's no force behind it.
That's why they recognised that, and they changed it so colleges would have EHC plans, and the authorities would still have that legal duty in place. But most students at 16 who are going onto college settings would lose the right to the support, and there's only students who stayed in school until they're 18 who continued. And then under the Children and Families Act, you continued that statutory support through the EHC plan, and you went to 25. So you are basically increasing the demographic of those who are entitled to that support by double, and you're not really putting the funding in to address that.
Yeah, I think everybody fails to remember that that there's just there's more people that are eligible to that support. That's why it's got more expensive. That's why the appeals are more. Yeah. And I think one of the judges that we speak to was saying that, think about last year, we got to that cohort after the changes came in where all of those children got to 25, and they were hoping that the appeals would placate after. And I think it has done that a little bit, but I'm not 100% sure on that, but it is something that's missed.
Yeah, and I think the appeal system is clogged through cases. I think the impression that which is being given is this is caused by kind of, as I say, parents pushing through. But that is just such an offensive thing in itself. Most parents have been in a situation where they've trusted the system. It hasn't worked. Their children's needs have got greater and the deficit in their learning has got higher. And it's usually the tribunal for most parents is an absolute last resort. But as the SEN review finds, it was always found that the tribunal plays a key critical role at ensuring that local authorities do their duty. So why are we cutting the tribunal's role at doing that? Why are we effectively cutting its hamstrings?
But Adam, the employment tribunal is full. Yeah. The criminal courts are full. Yeah. It's universal. It's not just the SEND tribunal, but because this money is coming out of local authority funding, because that's the way that the system is, and I know that there's ideas of the criminal courts and that being changed as well with the jury system, and there's like questions on that as well. But no one's addressing the employment tribunal. Why? Because that's private companies that are dealing with that.
Yeah.
That's got that they're footing the bill for that. But the employment tribunal, it's like a 2-year wait. Same.
So, I mean, for me, a lot of this also, like, again, I'm going to be clear with this. There are good local authorities. There are people who
Always.
are doing a good job. So I don't want to tarnish everyone with the same brush.
Yeah.
But there is a situation where it seems that local authorities have just decided, and a lot of authorities, that you say no to everything and see who challenges it. And I think those kind of cases are flooding the system. The answer to that is, you should be looking at rewarding local authorities for good practice, and you should also be penalising it for bad practice based on how many cases go to tribunal. And the tribunal will obviously hold the statistics for which local authorities are the ones who are repeatedly opposing appeals and repeatedly losing cases. And you could look at what kind of reprimand that would look like. I've said it before in this on this podcast that if you look at school exclusion cases, if a school has permanently excluded a student and it's been wholly unreasonable to do so, they can be fined up to £4,000. But there is nothing of equivalent in the SEN tribunal. So you wonder if you give good incentives, but also you challenge local authorities to actually do things well or penalise them, that a lot of these problems would go away.
Yeah.
Instead, I find the government have said, we're going to have more powers of Ofsted, and if a local authority doesn't do its job properly, then we will take away its ability to do so.
Yeah, everyone jumped up and down and was saying accountability at the Green Paper, and this is not. Accountability is nowhere to be seen in this.
Yeah.
If anything, I feel like it's very local authority coded.
Yeah.
I don't know if that's got anything to do with the ministers that are.
Well, we can't comment on their CVs, but people can look at the CVs and make their own judgments, I suppose.
Yeah, I think so. I did want to comment and mention EOTAS as well, because it's notably absent in the white paper. There seems to be no recognition that EOTAS is a thing, that it's necessary and reasonably required in some cases. Obviously, we've got the alternative provision, but these are supposed to be short-term placements. They're not supposed to be long-term placements. So it's not clear. It's just notably absent. It's not there.
Yeah, it's really interesting because it was something flagged almost immediately afterwards. I listened to Women's Hour after the legislation came through, which has got a specific discussion about SEND and parenting and the reforms coming through. Fundamentally, what was interesting about the discussion is how many people they asked who were commenting on it basically were not keen on all these changes, which was predominantly all the charities and parent groups and advocates in this area. The other thing was there was a young lady on it who is part of the EOTAS package, and she picked up on that straight away to say, we're not on here. It seems like we've been forgotten. So for those who don't know what an education otherwise than at school means, it means that we have some students who, because of their disabilities or their mental health, cannot attend a school. And the EHC plan in that situation would look at specific packages of provision. One of the reforms that we've been looking at ourselves and discussed in the past is making sure that there is better guidance for what a EOTAS is, and that should be covered clearly in a SEN code of practice moving forward, and what it should cover, how it should be reviewed, etc. At the moment, a lot of that has to be built in specifically each case, because every local authority has a different way of managing EOTAS packages. Mm-hmm. The idea is with the EOTAS packages is for most students, the idea would be gradual integration back into mainstream or a special school environment. But it also recognises that due to the disabilities of a student, that some students that's not possible. And it is concerning it's not there. But, there are aspects of it which I think the government are silent on, and purposely so. For instance, I feel like there is a demographic of students who are, your kind of, I suppose, high-functioning autistic students who may be academically really brilliant.
Yeah, high cognitive ability, able,
but significant deficits in social communication, social, emotional and physical needs. And those, say, with dyslexia profile, which usually have related needs as well, who have significant difficulties accessing a mainstream environment. It seems to me that when we say most complex needs, the government's intention is to restrict the ability of those students to get the support. And that would be a travesty, because it's always been based on individual needs and what an individual child requires. A lot of those students, like every student who potentially has SEN, if you put in an investment into their education at an early stage, then I feel like the return to the economy in the future for most students when their employment is massive. So yes, the bill might be high at this stage, but what you can do in the future for the economy is great. And, we've heard studies by the government on things like breakfast clubs and the return that, £1 spent on a breakfast club can do in terms of contribution to the economy later. That has gone completely silent in this whole debate. All we hear is attainment levels is not high enough for students with SEN in special schools. We've already talked about why that is just such a troubling and worrying kind of statement to make. And also, the role, I suppose, that those students who are kind of cognitively kind of mainstream but have those significant needs, if you address them, what they can do in the future. And I worry that we are going to have a silent, stashed at home situation where there are lots of students with those types of profiles who cannot cope with going to mainstream schools, cannot cope with being in them, and they are not entitled to EHC plans and that type of support, and therefore remain out of education, which is clearly not in anyone's interest.
It's interesting, isn't it? Because 2 years ago, the narrative in the media was for these NEET children not in education or training. And the fact that the EOTAS packages and the idea that not all children can be educated at a school in the traditional sense because of their neurodiversity or their particular needs, then not recognising that, I feel like is just going to exacerbate those children who aren't attending school and those who are dropping out of education and dropping out of sight. And I think it's almost like it's got a bit of amnesia from 2 years ago when this was an issue, when we were like, there are children who are being ignored because they can't go to school, they can't be educated in the traditional way. And I think that's when EOTAS packages and got kind of more into the mainstream media and people understood what they were, and they work really well for people. And look, with EOTAS, I think it's very rare that parents, I say this before, it's very rare, if not an occurrence, that parents will say when they have a child, I don't want my child to go to a school. I want them to be home educated forever. Because there's a social element of going to school. There's lots of skills that children do pick up on at school. And that is the ultimate aim with the EOTAS packages. Sometimes people don't get there, that young people don't get there, but that is the ultimate aim, to be able to integrate them back into school. But not recognising that is a need at all, I think, is just exacerbating the fact that these children that need it are going to fall off the radar if it's not available.
Well, I think the kind of approach of this white paper is just a very blunt tool which doesn't deal with the nuances of the situation. It feels like it's based on kind of government narrative rather than reality. The reality of why we're in the situation we are, all charities in this area make it very clear that the legal system, the tribunal, the legal protections are all things that they feel need to be in place. The issue is getting the right support quickly enough, making sure that we address need earlier on in the process, and perhaps those students who end up with EHC plans may not need them in the first place, and better training for staff at understanding need and addressing it in the classroom, and for local authorities across the country to do their duties properly. And that has been fundamentally the biggest problem.
Including defending cases better and being more organised. I mean, from someone who's worked at a local authority before, if you have to defend these cases better. A lot of the time why local authorities are losing are because their staff aren't trained properly. They don't have the places, and that's another thing I would say, that another issue is we need more school spaces. And I think that 3.7 billion, I think, could have been invested into building more schools up and down the country.
That's really interesting because obviously we've said it many times in this podcast, and most professionals in the area say the same, which is there has been a lack of building of specialist provision for 20 years. And actually the last government on its last legs actually introduced increase in terms of developing and building more SEN provision. Still not enough, but at least there's a recognition of the requirements for that. I believe it was in the I-paper a couple of days ago, there is a suggestion that local authorities are being pushed towards mainstream inclusion and de-incentivized in terms of developing and building SEN provision. The idea of a utopia where a mainstream school can do everything, it's just not borne out in pragmatic reality. And I think that's the whole problem with the SEN white paper and what we've seen coming through. It's on this like wonderful kind of sunshine, happy rainbows situation where a mainstream school can be just made suitable to everyone. 40 years of successive governments, case law, research into SEN has actually demonstrated that, yes, you can make more mainstream schools more inclusive, and you definitely should do that. And there are certain needs where if you change the teaching styles, can be addressed within that mainstream classroom. But there are also students out there who require a much higher level of provision, either within that mainstream school, additional support through EHC plans or, their new individual plans. But there are always going to be that group where mainstream is not suitable to them. And I think it's a kind of lost understanding that, all special schools should just be for profound and significant needs. There are students who are able, but because of their profile, means that attending a typical mainstream school, even within a provision or a unit, is not suitable. I mean, me and you, Salase, have many cases which come in around about October of students with, say, autism, developing emotional-based school avoidance as a consequence of going to a mainstream secondary school and it being unsuitable. Usually those schools have also got SEN provisions or ASD provisions in them.
Yeah, bases.
Yeah, and in that situation, the students are not leaving that provision to go to the rest of the school, and their needs are just not being addressed.
Yeah.
So that's inclusion, but it's actually exclusion.
Yeah, of course it is.
So it's great having all these taglines and this vision, but vision needs to be pragmatic. And it has to be born in reality of what's happening.
Yeah, I think ultimately it's been packaged up very nice. But when you open it up and you look into it, and it's been marketed very well, like that's what I mean. It's been packaged up very nice. But I think parents are alive to the fact that when you open up that package, it's not going to be great. It's going to be difficult for them because no matter what road you put parents on, right? From the parents that I've met, SEN parents that I've met, they are going to fight to get their children whatever it is that child needs. So it doesn't matter what road you put them on or what avenue you open that up to. They're gonna that fight is always going to be there because no one's going to give up on that. And it feels like it's almost like saying to parents, there's no point in if you keep knocking on this door. The tribunal aren't going to be able to give you the school that you want. It's up to the local authority, or you're not going to get the provision that you want because ultimately it's up to the school.
Well, it's kind of rewarding bad practice, isn't it?
Yeah, accountability again.
So you've got a tribunal which is doing justice and is actually achieving what it should do and what the government have set it out to do, which is to make sure that students with SEN are getting the support and provision they require. And what the tribunal has shown time and time again is the decisions at local authority level are wrong, fundamentally legally incorrect. So this system seems to be saying, we recognise that the tribunal is doing a really good job. In fact, it's doing too much of a good job. So what we're going to do is we're going to cut its hamstrings and reduce what it can do. Yeah. That doesn't seem to me to be listening to parents and their concerns. That seems to me to be saying, we are concerned about the cost of all of this and we don't want to fund it anymore. The reality is part of what the white paper is doing, you can do anyway, which is you develop your tier system within schools, but recognise that there are always students who are not going to fit within your tier system. Have a better national standard for what all schools should be providing without an EHC plan. Get that early intervention in there from professionals at an early stage, which is what they should be doing anyway. And, have a standardised system for measuring students' progress. but also recognising that there are always going to be those who need that EHC plan, and to make sure that it remains specified.
Exactly.
These packages of provision seem to remind me of some of the holidays I went on when I was a child in the 90s, which there were kind of package holidays which looked great on the website, and you turned up and half the hotel's still being built and it isn't what was promised. And I feel like we are going down that route, which is the government have got good intentions with some of this, but it's not going to be in place in time. I think there are other aspects of what they're doing, which is effectively to reduce parental rights, but also to reduce SEN children's rights. The winner in that situation is never the child.
Yeah.
And the whole point of the system at the moment is recognising that students with SEN are disadvantaged in the first place, and we need to address that.
Yeah. I think the thing that we need to remember as well is it's a white paper, so it's not definite. There is still, it's a skeleton, I suppose, and it's important to remember that when the Children and Families Act was first introduced, it looked very different to what it is now. So I think maybe that can be kind of like a beacon of hope for our listeners.
I think that's a positive bias, because I think so far...
Trying not to scaremonger.
Yeah, I think there's been a lot of kite waving from the government and the press over the changes that they will introduce. And I think we're in a situation where parents really do need to start standing up and writing to their MPs and saying they have real concern about this. The great thing for most parents, and we should link it into the podcast when we send it, is charities like EHCP have drafted a letter to go to MPs, which is available on their website, which outlines all of the concerns that we've raised today about the new system and why it should be challenged. Yes, white papers often look very different by the time we've got to the end of the process. This wasn't in the government's manifesto when it came into government in the first place. So there is the opportunity that it will be kind of scrutinised very heavily in Parliament and also by the House of Lords. But I think parents should be kind of aware that it's not just enough to say, oh, well, it won't come through as it's suggested. They need to kind of make sure that they're writing
need to lobby
and addressing.
Yeah.
Most of the stuff in the press, and maybe this is an indication of what the government will do, often it's said that this is the government's intention unless MPs receive significant backlash from parents about the system. So it's kind of almost inviting you to do so, and you should. I will be doing so. In fact, I already have. My MP is Helen Hayes, who was the chair of the SEN committee, and I've already written to her outlining my concerns. I would say that parents should be using the EHCP letter. We'll share it on our systems and addressing this as soon as they can. So,
thank you so much, and thank you to our listeners.
Thank you.